Good evening and welcome to the regular meeting of the City of Morgantown Board of Zoning Appeals. Please turn off all cell phones or other devices that may disrupt these proceedings. It is the duty of this board to consider requests for relief from the requirements of the city's zoning regulations, to consider conditional use permit requests, and to hear administrative appeals. The board conducts business in the following order: review, amend, and approve minutes of a previous meeting. We'll then move to unfinished business, conduct new business, and conclude with announcements from staff. Each request is heard in the order that it appears on the agenda for each conditional use and variance request. Following is done. We will introduce the agenda item, and the planning division will present a staff report which may or may not offer a recommendation. The applicant agent will be asked to present their justification for their request, which may include questions by members of the board. We'll then open a public hearing to hear testimony in support of or in opposition to the request. Rules regarding public testimony are as follows. Anyone wishing to testify during the public hearing may do so once recognized by the chair, or may, in lieu of oral testimony, submit written testimony to the chair. All recognized speakers must approach the podium, state their name and address for the record, and speak clearly into the microphone. All comments must be addressed to the board, should be relevant to the application, and may not be of a personal nature or personal attacks. All speakers will be limited to 5 minutes. If members of the board have any questions of the speaker, that time will not be counted toward the total of 5 minutes. If there is a large number of speakers, including many who are part of groups or organizations, we may, to avoid repetitive comments, elect to ask for a representative to speak on behalf of the group or organization. Speakers are notified that irrelevant comments or comments of a personal nature or personal attacks may result in the speaker forfeiting his/her opportunity to participate in the public hearing. We may elect to recognize the applicant agent at the end of the public hearing to provide rebuttal or additional comments, which will be limited to an additional 5 minutes. If members of the board have any questions of the applicant agent, that time will not be counted toward the 5 minutes. After all testimony is heard, I will declare the public hearing closed and no further public comment will be permitted. Uncivil, unruly, and/or disruptive behavior at any time during this meeting is prohibited and will result in removal from this public meeting. State law requires the board to consider findings of fact for each conditional use and variance request. The request cannot be granted unless a majority of the quorum present finds in the positive of all of the findings of fact. The board may elect to continue the hearing to another date if it needs additional information. Applicants and requesting parties will be notified in writing by the planning division of the board's findings and conclusions. Regardless of whether a request is approved or denied, decisions of the board can be appealed to the Circuit Court of Monongalia County within 30 days upon receipt of written notification from planning. Any work done relating to decisions rendered by this board during this 30-day period is at the sole financial risk of the applicant. Thank you for your consideration and respect for these proceedings and the opinions of all meeting participants. Call to order. Ms. Cook?
Here.
Mr. Misfeld?
Here.
Mr. DeWitt is absent. Mr. Benison is present. Please let the record show that we do have quorum. We have meeting minutes from previous meetings, and in this case it's, well, beginning with the August meeting, August 20th, 2025, and also for December 17th, 2025. Any comments or emendations?
No.
To the meeting minutes? I move then that we accept the meeting minutes from the August 20th and the December 17th, 2025 meetings as included in the packet. So we have a motion to accept, seconded by Ms. Cook. How do we vote?
Aye.
Aye. All right, so those meetings have been accepted into the record. Our first agenda item is unfinished business, CON 25-109, Brandon DeCenso at 52 Campus Drive, request by Brandon DeCenso for conditional use in compliance with section 1331.05 of the city's planning and zoning code regarding a neighborhood convenience store use, City Tax District 12 in the 3rd Ward, Tax Map 20, Parcel 80 in the R3 Multifamily Residential District.
So for CON 25-109, on the screen as well as in the packets is just an aerial view showing what that site looks like based on Mon County parcel information. The second slide is just a further zoomed in image just to give a bit clear of exactly what building we're talking about. The applicant is seeking a conditional use permit regarding a proposed neighborhood convenience store at the above referenced address. The structure is already existing and has apartments that exist above the proposed use space. Refer to the sections below in the packet. In summary, the applicant wishes to get a conditional use approval for a neighborhood convenience store at 52 Campus Drive. Please see the attached application to review the findings of fact listed, as staff have had no comments or modifications to these. The attachment can be found below the conditions. Staff have no objections to the applicant's request for this conditional use, and that if the Board of Zoning Appeals grants the applicant conditional use approval in accordance with the city's planning and zoning code, the use shall be subject to the following condition, being our standard condition. And that'll conclude staff report.
Thank you. Do we have is this a remote?
No, I'm not right here.
Oh, all right. We do have a representative for this case?
Yes, sir. I'm Brandon DeCenso.
Thank you.
How you guys doing? My name is Brandon DeCenso. This is my first BZA meeting, so I'm not sure necessarily how to run this.
That's fine. Just an overview, justification. Yeah, just can you state a reference address?
Yes, it's 52 Campus Drive.
Okay.
Yeah. Yes, I mean, high-level overview. Like Sailor just said, the property, it's a 14-unit multifamily building right now. Below on the ground floor of the structure, there's about a 1,000 square foot. Right now, it's kind of just like an empty space. The prior owner used that as his office that he ran his business out of. Kind of the idea that we're looking to move forward and push into action. We would like to put a convenience store in there. They're going to sell essentially, pretty regular items that you would find at any other convenience store, prepackaged good beverages. I do think that they intend to also try to sell alcohol at some point, but that's obviously pending them getting the proper approvals. Our case, or our opinion for why we think it would be good for the area is, we just think it adds it's an additional place where students can go get food and beverages. I think it's Sunnyside when you compare Sunnyside to more of like downtown. Sunnyside is more of like a little bit of like a food desert. The really the only place you can go get food and beverage in Sunnyside is a Sunnyside Superette, or kind of like the Starbucks that's at the bottom of View Place. The property, it's situated directly across the street from the Life Science Building, so I don't have an exact count for how many kids pass that location on a daily basis, but I would venture to say it's in between Monday and Friday. It's probably somewhere in the thousands, if not over 10. Probably over 10,000. And again, I think it just adds a good place. I think it's a place where it's a convenient place where kids can go get food and beverages, and I think overall it enhances the appeal of the neighborhood.
Mm-hmm. Okay. Any questions at this time?
No.
Are the days and hours of operation on here correct? It says 7 days a week, 10 to 8 p.m.
I think what they're looking for is more 8 to 10 p.m., but yes, 7 days a week.
8 a.m. to 10 p.m.?
Yes, sir.
Okay.
And then also too, just to give you a little bit of a high level, so myself and our company, we're not the ones who are going to be operating the convenience store. The gentleman's name is Harish Patel. His kind of experience in convenience stores, he owns, I don't know the locations of all of them that he does, but I know that he owns a couple of convenience stores at other college markets throughout, kind of like the Mid-Atlantic, and then he also owns a handful of Dunkin' Donuts, chain restaurants as well. So he is pretty well versed. This is not his first go around doing this kind of an operation. So we obviously would not move forward with him if we didn't feel that we had confidence in him being able to execute what he intended and planned to do.
What's the current use of this space? Office?
Well, so no, I mean, right now it's kind of just like it's just dead space really. It's about 1,000 square feet. There's a half bath and a full bath in there. We took over management of the building. It'll be 2 years this May. From when we took it over, the owner at the time, he was kind of using it as like a makeshift office where he ran. He also owned a couple other buildings in the area. That's kind of like where he ran his like property management side of it out of.
You mentioned the potential for alcohol sales.
Yes, sir.
If that comes to pass, do you anticipate a change in operating hours?
No, sir. So the other side to it too is obviously we have tenants that live in the building. So we're not trying to make this something where people are going in and out at all hours of the night. We're not trying to keep this open until like 2 o'clock in the morning or anything like that, because we do at the same time. We want to set the operator of the convenience store up for success, but at the same time we don't want to jeopardize kind of like the peace and well-being of the tenants that currently live there.
Is there going to be signage?
Yes, sir.
In what form?
Typical. I wish I brought you the visual for it, but it's going to be kind of like it's going to be like a vinyl banner sign. I think the proposed dimensions of it don't hold me to it. I can get this to you guys too as well if you would like.
Banner?
It's
like fabric banner?
No, it's like a more like a hard like vinyl banner.
All right.
It's going to go above the top of like the double door entrance into what is like now the office space. Call it.
As an additional note, also, any signage would have to get approved and permitted through the city
Right.
anyway.
Right.
So if, at the stage of where it's at now, if, something wouldn't be compliant, they would have to come back with the Board of Zoning Appeals or make it compliant for things like signage, things like that, for that space.
We do also, the operator of the convenience store, he also has came up with renderings for it. So again, I unfortunately don't have them with me tonight, but I'd be more than happy to share and supply you guys with those.
In terms of the signage, do you anticipate needing a variance for the area of the sign? Can you speak to that, or will it just be like a materials and illumination?
I think
Variance.
it's going to be more just materials. It's, to my knowledge, from based off what he sent me so far, it doesn't seem like it does not seem like a crazy or like intricate or over the top sign. Really, more or less, just seems like an area where he's going to be able to go put the name of the convenience store on and just be able to let people that pass the building know that is a place for business that they can go and get food and beverage.
All right.
We could this is when we could put a condition on if they have a different, because you're leasing this to an operator.
Yes,
right?
correct.
So that if they change, like if he gets out and then they get a new lessee, they would have to come back for another condition.
Any signage change, yeah.
Right? Because otherwise it would just carry with, it stays with the owner, so whoever he leases to could use it.
Correct, yeah. As long as they wouldn't be changing the use, anyone could go into that space and open up a neighborhood convenience store without coming back. The board can condition that. They've conditioned that in the past on things like restaurant private clubs and other things like that. So you could condition if this prospective buyer or leasee or whoever doesn't go into that space, or even after they're already in that space and it goes to somebody else, they could come back to the Board of Zoning Appeals to get approval.
That's a good idea. And there's no need, with regard to the rental space, the residential space, there's no anticipated, you're not anticipating separate signage for the residential units? No need for that?
No, sir.
Not that that's, your focus is on the convenience store, but just so that we understand.
So do you know anything about number of employees?
So from discussions that we've had, I mean, they plan to staff it probably, obviously depending on hours of operation, I think. I think over the weekend, they probably plan to have like about 2 people at all times, but it's going to fluctuate between 1 to 2.
Is there parking for that building?
Right.
Yeah, there's a 39-unit parking lot directly behind the building.
So in terms of the anticipated employees, there's accommodation for, in terms of the parking, right?
Yes, sir.
And accommodating said employees isn't going to adversely impact
No.
the residents who are already there? Again, I mean, your focus is on the convenience store, but just, big picture.
Yeah, for sure. No, so I mean, obviously, if you take 2 parking spaces away from that lot and dedicate them to the employees, obviously that's 2 less for, two less for the tenants of that building. But we do also manage a handful of buildings within the area, call it like within 100, 150 yards that have substantially sized lots. And that's also like right now the property that's in question, 52 Campus Drive, there's also a building right next door to it, which is 48 Campus Drive. They're kind of like sister buildings.
Right.
In total, between both of those, there's 59 beds, right? So obviously 59 beds, 39 parking spaces. There's a deficit in parking. Typically what we do right now, we manage a building down the street, and then we also manage a building across the street from it as well. So kind of how we do is like if once we hit that 39, once we fill up that parking lot, if any additional tenants in the building do want parking, we offer them to go park at one of the other lots that we manage in town.
All right. And Sailor, can you speak to that? You don't see any
It's
complications with entanglements with regard to available parking?
so
For this
that
mixed use, what's being proposed as mixed use?
Yeah, with the number of employees and then the size of the space, the number of spaces that they're asking for isn't a lot. And then they are also close enough within that proximity that they can use nearby parking, like off-site parking, and that would be a part of this conditional use kind of review. But yeah, that would kind of be encompassed into one conditional use for this neighborhood convenience store.
All right. Any other questions? Thank you. Yeah, we may have other questions for you.
Okay.
You ready for the public hearing? We are going to proceed to the public hearing for this case. So anyone wishing to speak in support of or in opposition to this case, CON 25-109, 52 Campus Drive, now's your opportunity to do so. Public hearing now open. Is there any correspondence on this?
Nope, I have not received any.
All right. Seeing no one, we're going to go ahead and close the public hearing.
I would say approve it with that condition.
Yeah, that's a good idea. Would you like to propose the language on that?
Okay, so I move to approve.
Well, let's do the findings of fact first.
Yeah.
Okay, so
Right.
the findings of fact, they seem pretty straightforward.
Right.
Let's just take another look at them. I mean, it's consistent with, I consider that part of Sunnyside. I mean, it's kind of mixed use in nature. So I would say that what's being proposed is more or less consistent with the mixed use character of that part of Sunnyside.
Yes.
It's a student population. They have vehicles, but at the same time, in my mind, that part of Sunnyside, it's kind of pedestrian oriented, which is consistent with what's being proposed here.
Right.
I mean, that's right where all the students cross.
Right, yeah. The students, they have vehicles, but it's pedestrian oriented. You've got the residents there, you've got what's being proposed for the convenience store, which is, it's convenient, so, it's people passing by, oh, it's a convenience store, I'm gonna take advantage of this. So I would say that the proposal is consistent with the character of this part of Sunnyside. So I move to accept the findings of fact for CON 25-109, 52 Campus Drive.
I second.
So we have a motion to accept findings of fact with a second by Ms. Cook. How do we vote?
Aye.
Aye. We've accepted the findings of fact. Any further discuss,
No.
would you like to propose we're gonna suggest a condition with regard to the anticipated signage proposed for, or anticipated for the convenience store.
Was there a staff condition too, or no?
Well, there's the standard condition, it's the standard condition.
Yeah, it's just, if any other modifications or changes to the site plan are made, they have to be compliant with the city's planning and zoning code, or they shall come back and seek variance relief, or just adjust it to be permitted.
So basically, if there are any changes after we make our determination, that will subject you to the need to come back for a separate variance,
Right.
basically. So.
Okay, so I'd move
propose that
to-
language?
Yeah, I'd move to approve the application with the condition, staff's condition and the additional condition that if the property is relet to a new lessee who wants to continue the convenience store use, that they come back to the board for an additional conditional use permit.
A second.
So if there's a change in signage, especially with regard to ownership, operation, that applicant will have to come before Zoning Board of Appeals for approval for that different signage. So we have a motion to grant the requested conditional use for CON 25-109, subject to the proposed condition with regard to changes in signage with changes in ownership, operation of convenience stores at the property.
And I second it.
And we have a second by Ms. Cook. So we have the motion, it's been seconded, how do we vote?
Aye.
Aye. So we've granted your request for the conditional use. You will receive written notification from planning in about a week, but do keep in mind, as we stated at the top of the meeting, any work that you undertake, it can be appealed to the Circuit Court of Monongalia County. It's a 30-day appeals window. Any work that you undertake in that window that's subject to appeal at the court, you do at your sole financial risk.
Yes, sir.
Thank you very much.
Thank you, appreciate it.
Good luck. Thank you very much for coming down. All right, next case we're moving to new business. This is another conditional use. This is CON 25-117, Nicholas Romanoli at 130 Fayette Street. Request by Nicholas Romanoli on behalf of Dave Flores for conditional use in compliance with section 1331.05 of the city's planning and zoning code regarding a dwelling, two-family use, city tax district 11, second ward, tax map 26A, parcel 87 in the B4 general business district.
So on CON 25-117, if you'll look up at the screen, here's just an aerial view of what that site looks like. It's in the packet as well. And then here's a zoomed in view of what the property looks like, just to get a better orientation of where the structure is, as well as that parking space in the back. The applicant is seeking a conditional use permit regarding a dwelling, two-family at the above referenced address. As you can see, the structure is already existing and has previously been a commercial salon space. Site plan can be found below conditions as an attachment. Refer to the sections of code below in the staff report. In summary, the applicant wishes to get a conditional use approval, get that in a second, use approval for a two-family dwelling at 130 Fayette Street. Please see the attached application to review the findings of fact listed, as staff have had no comments or modifications to these. The attachment can be found below the conditions. Staff have no objections to the applicant's request for conditional use as well. And if the Board of Zoning Appeals grants the applicant conditional use, approval in accordance with the city's planning and zoning code, the use shall be subject to the following conditioning being our standard conditions. And then that'll be the staff report.
Yeah, right, it's right down the slope.
He's done.
Thank you. All right, so do we have a representative for this case? Thank you very much. Just state your name and a reference address.
So I'm Carmine Lindsay, and my home address is 206 Manbeck Road.
Excellent.
My son's a student here and a student athlete, so that was sort of the whole reason behind this project. We found a very suitable house in a safe place, walking distance to his class, and we can get his teammates parking so they can drive up to the Coliseum every day. It was like pretty much the perfect scenario. And because of the ordinances, we needed to make it 2 units so we could have 5 kids there. So there's 2 bedrooms downstairs and 3 up. So that was the reason for the ask to do it 2 residential units so we can get his teammates there. We have the parking for it. So that's what we're trying to do.
Okay, so but it's only going to be like 1 unit?
Well, it actually is laid out as 2.
Okay.
But there's a door in between. I am sure they're gonna leave the door open. I mean, they wrestle with each other every day. I'm sure they're probably gonna be leaving doors open, but it is actually literally laid out as 2 units. Because it used to be like an upstairs commercial, and then the upstairs was part of that, and the downstairs was separate.
Right.
So pretty much, we're gonna leave the layout the same. Literally no construction on the layout. We just wanted to make it so we would be able to compliantly have the right amount of kids in there.
Right. And then you've factored in parking.
Yes, then we had to have the right. So 5, basically it'll be 2 downstairs, 3 upstairs, so, and 5. Actually, technically, when we measured it, we drew out 6 spots, but it's advertised as 5. But there's probably 6 there. There's 5 comfortable.
Right.
And they'll get that striped and stuff when it gets to that part of the permitting stage. Right now, I don't believe it's striped. Are you familiar? I don't
I think it
is.
was.
Yeah, it's like old. But if this is approved and then they're able to pursue permitting for it, they'll have to restripe it, make sure the lot's compliant, stuff like that with in regards to the parking. But they have enough spaces. They'll just have to figure out.
For the area, they meet, 6 meets the requirement.
Yeah, they only needed to provide no more than like 4 or
No more?
5.
Oh, really?
Was for a duplex with the number of people in that duplex. That's
Right.
about where they're at. 7, I think. Yeah, based on what our previous discussion, or me and Dave's previous discussion, about 7 is they could probably fit 7 even in there, but they may not even be able to because of the cap on how many parking spots you can have. But yeah, they're covered on their
And they're
spaces
close enough to walk.
sufficiently. Sure.
What sport?
Wrestling.
Okay.
Yeah. And it's almost as if you're reverting to, it's consistent with, it has a history, the structure as a residential.
I'm pretty sure it was a house. I mean, the
Yeah,
owner,
I've definitely-
the owner's online, but I think, because it certainly was set up as bedrooms.
Yeah, this is
Right.
Tonique's, right?
I believe so.
Yes, okay.
You're saying, yeah.
Because it's right next door to the Realty, right?
It is, yeah, right there.
Yes, it was Tony.
Okay, cool.
Good.
Thank you very much.
Thank you, guys.
Okay, let's open the public hearing. We're going to open the public hearing for CON 25-1, 130 Fayette Street. Anyone wishing to speak in support of or in opposition to this case?
I could speak.
All right.
Uh,
Can you just state your name and,
Address.
Nicholas Romanoli, the owner.
okay? Do you want to use the 130 Fayette Street as a reference address?
Yes.
Okay.
130 Fayette Street was a hair salon for 20 years, and before that, it was a residence. And before that, it was a family residence. And we have kept everything updated. All the apartment buildings next to us don't have parking, but I do. I'm the only building that has parking there. And the building next to me has, I think, 3 or 4 units with no parking. The building next to me has 2 or 3 units with no parking. And the one across the street has no parking, and that's 4 units. So the building that I own there is perfect for what they want to do with it. And there's plenty of parking, 5 parking spaces easily, 7 if you want to pack them in. So that building there is the only one that has parking.
Right.
Works out good.
Thank you.
That's all, thank you.
Anyone else wishing to speak in support of an opposition to this case?
Yeah, I would like to say something. My name is David Flores. I'm the agent helping Carmine with this. The one thing, you know, Carmine really wanted a safe place for his kids and his kids' friends, and they're part of the wrestling team. The problem, a lot of places in Morgantown are very old. They are, you know, not so safe and habitable. Nick's property is very safe and very habitable, and that's the biggest reason why. One of the biggest reasons why, you know, we would like this property to be a residence for them is because of the safety. It's a very solid property. There's no wavy floors or you know, bad foundation. It's just a really safe place with parking downtown that we see. And I also spoke, you know, with Code about this, and they're in agreement that it kind of hits all the buckets in the sense that it has parking. It is kind of laid out as a residential property, and it's extremely safe for students to live in. So that's all I'd like to say, but it just makes a lot of sense for that property to be a residence for kids as well.
Okay.
Thank you. Anyone else? All right, we're going to close the public hearing for this case. All right, so I'm going to make a motion to accept the findings of fact for CON 25-117.
I second.
So we have a motion to accept findings of fact, seconded by Ms. Cook. Any other discussion? I mean, it's
Got parking.
got parking,
Got everything.
it's what's being proposed is consistent with the history of the property. Yeah, okay. We have a motion to accept the findings of fact, seconded. How do we vote?
Aye.
Aye. I move that we grant the requested conditional use, or the request for conditional use for this case at 130 Fayette Street. Do we have a second?
Second.
We have a motion to grant the requested conditional use, seconded by Ms. Felt. How do we vote?
Aye.
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 We've granted your request for conditional use for the subject property. You will receive written notification from planning soon. But again, it can be appealed to the Circuit Court of Montague County, and any work that you do during that 30-day appeals window, you do at your sole financial risk. Thank you very much.
I said, go win.
Yeah, have a good season. All right, so moving on to the next case under new business. This is a variance request, or VAR 25-113, Garrett Lane at 371 Mansion Avenue, request by Garrett Lane for variance relief from section 1365.04 of the city's planning and zoning code regarding off-street parking, city tax district 13, in the 5th Ward, tax map 21, parcel 105 in the R1A single-family residential district.
So for VAR 25113, on the screen is a zoom view of the property in reference, as well as that dashed line being the property line for that property. The applicant is seeking a variance regarding parking standards for a single-family dwelling. This house was previously vacant, and the applicant is trying to remodel the structure to current city standards. I refer to the sections of code below in the packet. In summary, the applicant wishes to get a variance regarding 2 off-street parking spaces at the referenced address. Please see the attached application to review the finding of fact listed, as staff have had no comments or modifications to these. This attachment can be found below the conditions. Planning staff have no objections to the applicant's request for a variance. If the Board of Zoning Appeals grants the applicant variance relief in accordance with the city's planning and zoning code, the use shall be subject to the following condition, being our 1 standard condition. And then that'll conclude staff report.
Could you show us where the parking will be? That you said there's going to be 2 spaces now?
That is what they're requesting, 2 off-street
And where would
parking
they be?
spaces.
Can you just kind of?
No, that's what the variance is for. They
So
need to
waiving
provide 2
requirement.
spaces, they are unable to, so they are asking for 2 spaces.
Oh, it's a waive it.
Yeah.
Yep. Yeah, single-family dwellings need 2 spaces. They are unable to do as such, so they're requesting 2 spaces varianced. So they would not have to provide 2 parking spaces for the single-family dwelling.
At all?
Yep.
Is there enough parking on the road or whatever there? I guess we need to listen.
Yeah, the applicant can maybe answer that better, but
Okay.
that wouldn't, you know.
All right. Yeah, so, thank you, Mr. Dumpin. Do we have a representative for this case?
Luke Garrett Lane, the applicant. There is a space.
Can you just state a reference address for this case?
Oh,
You can use the, you know,
371 Mansion Avenue.
okay.
There is an area in front of the house where I park my truck. However, it is not nearly large enough to fit 2 vehicles. My truck will barely fit there.
Right,
And on the side there where the trees are,
yeah,
there isn't an accessible way to get there, because coming from one way, I would have to go through WVU's land to get onto the land for that property. And there is a retaining wall on the street side that would have to be taken out to get to the property beside the house.
right,
So there is potentially 1 parking spot there, but no feasible way for me to put a second.
so there's no way to create like a drive immediately because of, is it because of the gradient?
It's
Oh,
also not wide enough either. The side of the reference property isn't wide enough for a driveway there to not be in violation of setbacks on the side or another.
And the retaining wall there is 4.5 to 5 feet tall. So in the area from road to there, I would have to lift a significant amount, which would make it hard to enter the property if it were bad weather conditions or anything of the sort, and would be a good slope under the best of conditions.
Right,
Plus taking out the retaining wall that is functioning to hold back the hillside there.
right, right.
What's the dotted line there, Sailor? Is that
That's their
part-
property line.
Oh, it is?
Yep. So that dashed line that you're seeing on there is their parcel.
Yeah. That's, yeah,
Regrettably, they built it clear at the front of the property line next to the road. Had they built it back farther on the property, it would have been easier to make the parking spaces.
right.
Okay.
So that's WVU on the backside?
On the back and right-hand side is owned by WVU.
Okay.
So, I mean, there's a requirement for 2, and you have room for at least 1 vehicle
Yes,
on street.
there's one there where I can pull just in front of the house.
Right.
That's
That-
not on the street, but there's no way the two will fit there unless
Right.
somebody was driving a moped or something of that.
And that's also not even on their property, so it's not counted towards off-street parking. That's more street parking, actually, for what he's referencing.
So
So
basically,
he couldn't even fit with the setback requirements, he couldn't put a parking space there even if he could get.
Correct, yeah, the property line pretty much just goes directly to the front of the house. There's a couple feet at some parts it's really close, especially on the corner there, it's almost touching it, give or take, a foot or two. And then on the right side there, if a suggestion would have been to go up the side of it, it's not wide enough to be compliant as a parking, it's not wide enough for the width requirement, so that wouldn't be permitted either. Without asking for either one or two other variances. And then even then, it would, they would
tight squeeze.
probably not even be able to fit
And
a vehicle.
I mean, it's not as if he created the problem, he waltzed into the
Yeah.
situation as is, so.
Okay,
Any
no.
Any questions? No. I think we're all set. We'll go ahead and open the public hearing for this. Okay, so we're going to open the public hearing for this case, VAR 25-113 at 371 Mansion Avenue. Anyone wishing to speak in support of or in opposition to this case, please do so now. Seeing no one, we're going to open the public hearing. No correspondence or anything further to add?
Nope.
Okay, I'm going to make a motion, well, I mean,
I can, or I can. I move that we accept the findings of fact as stated in the packet.
Second.
so we have a motion to accept the findings of fact. The findings of fact they're very straightforward. They speak to the physical characteristics of the site. We have a second by Mr. Misfeld, so how do we vote on the findings of fact? Aye.
I'll also make a motion to grant the variance with the one,
The standard
yeah, the
condition.
standard condition mentioned by the city.
Okay, we have a motion. I'm going to go ahead and second that motion to grant the requested variance for 371 Mansion Avenue. How do we vote?
Aye.
Aye. So we've granted your variance. Again, you will receive written notification from planning. The determination that we just rendered can be appealed to the Circuit Court of Montague County. It's a 30-day appeals window. Any work that you undertake in that appeals window, you do at your sole financial risk. Thank you very much.
Thank you.
You're welcome. Next case, we have a signage case, VAR 25-119 City Neon for 356 High Street. Request by City Neon on behalf of Cold Stone Creamery for variance relief from section 1369.08 of the city's planning and zoning code regarding internal illumination standards, City Tax District 11, 2nd Ward, Tax Map 26A, Parcel 110, the B4 General Business District.
Yep. For VAR 25119 for City Neon. On the screen as well as in the packet is just kind of that design of what that signage will look like, dimensions, illumination, standard things like that. The applicant is seeking a variance regarding internal illumination standards for signs in the B4 district. The sign size and dimensions are permitted other than its illumination standards. The sign will also be the same approximate size and shape as the one that's previously there, the one that's existing currently, which was illuminated by neon. Refer to the sections of the code below as well as the submitted designs. In summary, the applicant wishes to get a variance regarding illumination, a sign at the property addressed at 356 High Street. See the attached application to review the findings of fact. Listed as staff have had no comments or modifications to these. Those can be found below the conditions. Planning staff have no objections to the applicant's request for this variance relief. If the Board of Zoning Appeals grants the applicant variance relief in accordance with the city's planning and zoning code, you shall be subject to the one standard condition, and that is all.
All right, thank you very much. Do we have a representative for this case?
Good evening, my name is Joshua Katz with City Neon.
Okay.
All right. Do you have anything to add?
Just the fact
Oh,
that LEDs.
yeah, actually, could you restate your name and just provide a reference address for your case?
Again, my name is Joshua Katz, K-E-T-Z, with City Neon at 1095 Chaplain Road in Morgantown.
Thank you. So you're basically requesting the variance for the illumination part of the signage, correct? It's not for.
That's correct.
It's not for area, not for materials. Are you
Correct.
going, is it going to be timed illumination? Can you speak to, is it just going to be in relation to business hours for Cold Stone?
Yes.
So yes, it will, the illumination will be on a timer, or it will be turned off at close of business?
It will be on a timer, sir.
What color neon and is it going to be flashing?
There's no flashing involved, no. The sign has a red acrylic face, and the internal light of it would just be white LEDs. So, I mean, you'll get the ambiance of a red light, but it's just the acrylic itself.
Oh, okay.
Okay. And then Cold Stone is open through, what is it, 9 PM or 10 PM?
10 p.m., I believe.
Okay.
So in terms of the residences, the rentals downtown.
I mean, it's literally going to look identical to the sign that's up, other than the fact that it is no longer going to be neon and it will be LED.
Right.
Okay.
Yeah, they already have all that signage.
Yeah, so pretty straightforward.
All right, thank you.
Yes, sir.
Yeah, let's go ahead and open the public hearing for this case. We're opening the public hearing for VAR 25-119, City Neon, 356 High Street. Anyone wishing to speak in support of or in opposition to this case, now is your opportunity to do so. Seeing no one, we're going to close the public hearing. No correspondence for this case, and just the standard condition. Right.
These are the ones that I think we should have like a running order to just like grant these LED variances.
Right.
It's okay though, it's easy.
All right, so I move that we accept the findings of fact for VAR 25-119. The variance request is just for illumination. It's not even for area
Doesn't change the size.
or materials.
I second.
So we have a motion to grant or accept the findings of fact, seconded by Ms. Cook. How do we vote?
Aye.
Aye. I move that we grant the requested variance or the variance request for VAR 25-119. It's an illumination variance request for 356 High Street.
With the condition that is mentioned in the packet, I second.
With this, yes, okay. So we have a motion to grant the variance request, seconded by Ms. Cook. How do we vote?
Aye.
Aye. So, sir, Mr. Katz, we've granted your request. You will receive written notification from planning. The determination that we just rendered is subject to appeal, the Mon County Circuit Court of Appeals. So any work that you do in that 30-day appeals window, you do at your sole financial risk. Thank you very much.
Thank you, appreciate your time, thank you.
Thank you very much. All right, so moving to VAR 25-122, Matt Lacey at 670 Southview Street. Request by Matt Lacey for variance relief from section 1333.05 of the city's planning and zoning code regarding encroachments into setbacks. City Tax District 15, 7th Ward, Tax Map 54, Parcel 158.1 in the R1 Single Family Residential District.
So VAR 25-122 on the screen as well as in the packet is just similar to the last ones. An aerial view of the property, what it looks like on there. The applicant is seeking a variance regarding encroachments into setbacks in an R1 single-family dwelling district. The applicant constructed a pool and patio without receiving a building permit and is now seeking variance relief for that project. The pool structure itself is within its required setback distance, but the patio around it is encroaching approximately 3 feet into that setback. Those setbacks were determined using Mon County parcel information as a survey was not provided. The project has a building permit applied for, which is contingent on this variance as well, and then refer to the sections of code below. To address this issue, the applicant seeks a variance in the amount of 3 feet for the proposed improvements at the referenced address. Please see the attached application to review the findings of fact listed, as staff had no comments or modifications. The attachment can be found below the conditions. Staff have no objections to the applicant's request for this variance relief, and if the Board of Zoning Appeals grants the applicant variance relief from section 133305 of the city's planning and zoning code, the proposed improvement will be subject to the following condition, being our standard condition, and then that'll be it.
All right. Do we have a representative for this case?
Sir, I'm Carly Lacey from 670 Southview Street, and thank you for hearing our request today. The issue of whether or not we had a building permit for this project was contested in municipal court, and we resolved that issue, and as part of that resolution, we're here today asking for this variance. It was a condition of the resolution. So we believe we're within the 3 feet requirements all around the pool, but we did not get a survey to prove that, and we are therefore here relying on the city's software. But I would note that certain software that the city used in our municipal court hearing, I was able to show was inaccurate. So that's really neither here nor there in this situation, but I just bring that up. So we did start looking at this project in 2020, and at that time, Chris Fletcher was with the city, and we worked with him to make sure that our concrete was going to be within the appropriate setbacks, and he did agree with our placement at that time. Because of COVID, we couldn't get a pool for a long time, so we had to wait for that, and that's why this was all delayed so long. I would note that the pool is, in the concrete, is within a fence that was previously approved by the city. And that I would also note that there's no negative impact on the neighboring property. I know this partially because we own one of the neighboring properties. And I would also note that all of our neighbors have taken part in festivities at our pool, and they've never voiced any concerns. So that's really all I wanted to represent to you today, but if you have any questions, I'm happy to answer them.
I think you did your homework well.
It sounds as if you did your due diligence.
Yeah.
Was this the only variance you had to apply for as part of the municipal court?
As far as I know.
Okay.
There have been some surprises along the way, so as far as I know, this is the only variance we need.
I think they would bring them all up at one time, wouldn't they?
Yep.
Okay. Okay.
Can you, so one more time, can you speak to what your responsibility was in terms of the permit, the initial permit?
Sure.
Because that's an important component to this situation.
I agree. We applied for the permit, and the city, it's contested whether or not it was actually ever reviewed. There is a law that that was enacted right before we started the project that said after 60 days, if the city doesn't respond to a permit application, it's automatically approved.
Right.
And we're
It's understood as approved, even if the actual, it's not issued, yeah, okay.
I should note the city disagrees with me that that applies to them. However, I don't have anything to refute that would apply because they never presented anything. So we're just trying to work with them to make the situation, to fit within what they need to make this situation be resolved.
So the law is in the city right now that if they enact a law, I mean, if you apply for a permit, they have to answer it within 60 days or it's automatically approved.
In my opinion, yes. And I'm an attorney, and I worked in the past with the city attorney, so she and I both sat down and looked at it. She could not find a reason why the law would not apply. However, code enforcement disagreed with us.
Well, if you, again, it sounds as if you did your due diligence. You provided the necessary inputs with the understanding that, or the expectation in this, at the end of this 60-day period, this is what we're expecting as a response.
Right, and just for transparency, the one thing that the city took issue with was the fact that we started the project before the end of the 60 days. We did start the digging. And the reason for that was because of the timing. We had called the city several times to try to get the permit pushed through, and couldn't get a response. And as I stated, we had already waited 5 or 4 years, I guess, at the time for a pool. And so the timing it was like, either we do this now or we may not be able to do it. And so that was what they took issue with. But the project, the pool itself was not put in, nor the concrete or anything, until after that 60 days had been.
Oh, right.
Could have told him your dog don't know. Down the hole. For his bone. No, just kidding.
Any other questions?
Hold it again.
Yeah, we may have other questions for you, but
Yeah.
thank you very much.
Yeah,
Thank you.
All right, we're going to go ahead and open the public hearing for this case. This is for VAR 25-122, Matt Lacy, 670 Southview Street. Anyone wishing to speak in support of or in opposition to this? Now's your chance to do so. Seeing no one, we're going to close the public hearing. And there's no correspondence. Nope. For this. Well,
what are you thinking?
it sounds to me as if due diligence was done.
Yes.
And it's not as if, there was the reasonable expectation, we're making application for this permit, and it sounds as if there was a non-response by the other party.
And then they got upset because they started digging a little bit early. But there was a lot of,
So what's
like you
this-
said, with the
the
contact
setback
with the
supposed to
city.
be?
Can you, what's the, so for this setback, can you speak to what the required?
The setback for it is 3 feet. That would be like 3 feet away from the property. And based on Mon County parcel records, the property line is the fence, which you're allowed to build a fence on your property line. So they're asking for the full 3 feet.
Partly because the fence is on the property line.
Yep.
Oh, go ahead.
But there's already a fence, there's already a fence there.
Yeah, the fence isn't a concern. The fences
And you
could
didn't
be-
erect the fence, the fence was already
No,
there?
we
Never
did,
come up.
and
They
it's
had
actually
it.
not on, sorry. It's actually not on the property line. It's a foot to a foot and a half off the property line. But we did get a permit, and that was approved by the city at the time.
Just a permit or a variance? I thought you said you had a variance for the fence before.
No, I'm sorry. I think it was just a permit.
Mhm.
That's all we were required at the time. Because
Okay.
it was, like I said, it's a foot off, and then the concrete is a couple of feet from it, so it's.
And also, I see somebody trying to comply with the city, and then, like they're saying, surprises come up in which nobody intended. It's not a blatant, I'm disregarding the city and doing my stuff.
So this is just a deck, it's not like blocking light or views or anything?
No, it's just a concrete
Sight lines.
patio. We had to have so much concrete around the pool because it's a fiberglass pool. So-
Okay.
To stabilize this, to stabilize it?
Yes, yes. That's
So
what
it's
the
a
pool guy
structural,
tells me.
it's a structural requirement.
I
So-
don't hold myself out as an expert.
Right.
So the cement is like, the margin of the cement is right on the property line?
No, we believe it's 3 feet off the property line, but like I said, we didn't do a survey because frankly, we didn't put the money into it, and this all happened pretty quickly. So we were just relying on the city software, and the software goes by the fence, and so that's why we're getting the variance out of an abundance of caution.
Okay.
Yeah,
To
thank-
comply with standards. Appreciate that.
All right, thank you.
Yeah. I'm hearing due diligence for as much as they knew. I had no. What about you, Mr.
I don't really have a problem with it. It
I don't
seems to be
either.
more I mean, probably the more pressing issue is where the property line actually is.
Right.
And that's gonna be, that would be decided somewhere else anyways.
And the pool's already in, and I'm like, but
It's not like a tall structure, it's not
I
like a
think-
big shed block right on a property
again,
line.
I keep hearing
either.
due diligence
Yeah,
and
go-
things got messed up.
that's all right. If you'd like to
Yeah,
add,
please
go
approve.
right ahead.
You mentioned something that I thought I should mention. When we put the fence in, it was right when we built the house, and so the survey markers were still up for that. So that's how we knew it was a foot off the property line. Those are now gone because there's been, it's been 6 years or so those have all been.
Okay.
So that's how we knew it was, sorry.
Okay, no, you're good, thank you. I prefer to know.
I mean, I would move to approve the findings of fact as stated.
And that last statement, the cement was a foot off of when the stakes, when it was still staked. And it's still a foot off, away off of the actual property line.
Well, if you're right about the property line, then you're in compliance with the setback, right?
That is correct. Yep.
Okay, that's good to hear.
All right, I move to accept the findings of fact for this case, VAR 25-122, 670 South View Street.
I second.
There was a public hearing, right? Yes or no?
Yes.
Okay, I just,
Whoa, did we?
No, we didn't.
Yeah, we did.
no?
I'm almost sure we did.
Well, we didn't close it.
Okay, close it,
Okay,
You know what, let's we'll reopen it,
just in case.
just in case. We are going to, just to make sure, because we didn't close it. So
Right.
we're gonna open the public hearing for this case, VAR 25-122, 670 Southview Street. All right, anyone additional wishing to speak in support of or in opposition to this case, please do so now. We did open it, but didn't close it.
Okay.
Because I asked about correspondence.
Okay.
All right, seeing no one, we are going, and we're going to note there's no correspondence for this case. We're going to close the public hearing. All right, we have a motion to accept the findings of fact for VAR 25-122, 670 Southview Street. Do we
Yeah, I
have
seconded.
a second?
I second.
So we have a motion to accept the findings of fact. Second, or we have a second motion or a motion in support. How do we vote? Aye. I move to grant the requested variance for this case for VAR 25-122, 670 Southview Street, subject to the standard condition. Do we have a second?
Second.
All right, we have a motion to grant the requested variance, seconded by Mr. Misfelt. How do we vote?
Aye.
Aye. So we've granted your requested, or your request for a variance. You will receive written notification from planning. But the determination we just rendered is subject to appeal in the Mon County Circuit Court of Appeals. And any work that you undertake, any additional work you undertake in that appeals window, you do at your sole financial risk. Thank you very much.
Thank you.
Yeah.
Have a good evening. All right, we're moving to, well, they're separated out. We have an additional 5 cases for the same subject parcel or development project, referenced as, well, I'll just read them all. So the first is VAR 26-008 ARJ LLC. This is all at 264 Hartman Run Road. The first case is request by ARJ LLC for variance relief from section 1347.03 of the city's planning and zoning code regarding lot frontage. City Tax District 14, 6th Ward Tax Map 32A, parcels 13.1, 25, and 26.1 in the B2 Service Business District. Then we have VAR 26.009 ARJ LLC, also 264 Hartman Run Road. This is a request by ARJ LLC for variance relief from section 1347.03 of the city's planning and zoning code regarding lot size City Tax District 14 in the 6th Ward, Tax Map 32A, parcels 13.1, 25, and 26.1 in the B2 Service Business District. The third variance request related to this application is VAR 26.010 by ARJ LLC, 264 Hartman Run Road, request by ARJ LLC for variance relief from section 1347.03 of the city's planning and zoning code regarding lot depth. City Tax District 14 in the 6th Ward, Tax Map 32A, parcels 13.1, 25, and 26.1 in the B2 Service Business District. VAR 26.011, 011, ARJ LLC, also 264 Hartman Run Road, request by ARJ LLC for variance relief from section 1365.09 of the city's planning and zoning code regarding driveway layout and design. City Tax District 14, 6th Ward, Tax Map 32A, parcels 13.1, 25, and 26.1 in the B2 Service Business District. And the last related variance request is referenced as VAR 26.012 ARJ LLC, 264 Hartman Run Road, request by ARJ LLC for variance relief from section 1347.04 of the city's planning and zoning code regarding rear setbacks. City Tax District 14, 6th Ward, Tax Map 32A, parcels 13.1, 25, and 26.1, again in the B2 Service Business District.
So I will be doing a kind of combined staff report for these. VAR 26008 to VAR 26012. Here's the reference property as well as shown in your packets. It's a kind of undeveloped combination of 3 parcels together, and then attached in the packets as well as on the screen is a site plan layout of what the site will look like, as well as our city planner going around kind of handing out site plans to give you a little bit of easier time looking at them.
Thanks.
So I will go in order. VAR 26008. They're seeking variance relief regarding lot. Well, this says lot size standards for dwelling townhouse use. The development project will involve 104 townhouses across the 3 lots shown above. The applicant wishes to reduce the lot frontage from 60 feet to 40 feet for the referenced area. Refer to addendum A for lot sizes, layout, additional information, etc. Refer to sections of code and packet as well. In summary, the applicant wishes to get a variance regarding 40 feet of frontage for the referenced address. So I'm going to then move on to the next one, because all the, I will read 2 more, but I'll read all the conditions at the end. Please see the attached application to review the findings of fact listed, as staff have had no comments or modifications. The attachments can be found below. Planning staff support the applicant's request for variance. The division of internal lots is what is causing the issue for variance, while the development as a whole is not. And then I will read those conditions later. So moving on to VAR 26009 for the same address, same supplementals on screen that were shown work. The applicant is seeking variance regarding lot size standards for dwelling townhouse use. The development project will once again involve 104 townhouses across the 3 lots shown above. The applicant wishes to reduce the lot size from 6,000 square feet to 1,750 square feet for the referenced area. Refer to addendum A for lot sizes, layout, and additional information, and then code below. In summary, the applicant wishes to get the variance regarding 5,250 square feet at the referenced address. See the attached application to review the findings of fact listed, as staff have had no comments or modifications. Planning staff support the applicant's request for variance. The division of internal lots is what is causing the need for this variance, while the development as a whole is not. Then the conditions will be referenced later.
Wait, I missed that part, Mr. Saylor.
Yeah, could you restate that last point?
The planning staff support the applicant's request for a variance. The division of internal lots is what is causing the need for this variance, while the development as a whole is not. To kind of expand upon that, if you look at the site plan on screen as well as in the packets, you'll see how the townhouses are being cut up. If the townhouses as a structure were on one parcel, they wouldn't necessarily need most or all of some of these variances. However, they're dividing the parcels up for individual ownership of their part of the townhouse. And that can be discussed a little bit later by the applicant, but that is what I mean in that kind of support rationale section. Moving to VAR 26010, ARJ LLC at the referenced address. The applicant is seeking a variance regarding lot depth standards for dwelling townhouse use. The development project will involve, again, 104 townhouses across the 3 lots shown above. The specific lots requiring this variance can be found on Addendum B. The applicant wishes to reduce the lot depth from 100 feet to 71 feet for the referenced area. Refer to Addendum A as well for lot sizes, layout, and additional information. Refer to the sections of code below. In summary, the applicant wishes to get a variance regarding 29 feet for lot depth at the referenced address. See the attached application to review the findings of fact listed. If staff have had no comments or modifications, the attachment can be found below conditions. Planning staff support the applicant's request for this variance. The division of internal lots is what is causing the need for this variance, while the development as a whole is not, as well as the only exception to this is exterior lot number 37, and refer to the findings of fact for supported rationale for that.
It's topography.
Yeah, maybe.
VAR 26011. The applicant is seeking variance regarding driveway standards for a dwelling townhouse use. This development project will involve 104 townhouses as previously referenced. Refer to Addendum B for the specification on distance measurements for each of the lots. The applicant wishes to reduce the lot depth from 15 feet to 0.25 feet for the referenced area. Refer to Addendum A again for the layouts and additional information. In summary, the applicant wishes to get a variance regarding 14.75 feet for driveway distance to an adjoining residential property line at the referenced address. See the attached application to review the findings of fact listed. As staff have had no comments or modifications, planning staff support the applicant's request for this variance. None of the lots require this variance in regard to neighboring or external properties. This division of internal lots is the only reason causing this variance. The development as a whole is not, as stated. This isn't in regards to any external properties.
Was there any correspondence
Nope.
in relation to the driveway issue?
No, there was no correspondence for any of these, any of the variances referenced, and the driveways are only those internal ones. Their external driveway kind of entrance, the road itself is fine for planning purposes. This is in regards to the internal driveways for each of the relevant properties. They would have to be 15 feet away from adjoining residential properties. And again, because they're kind of cutting up the townhouses for individual sale, that's where that kicks into the 15 feet. But whereas if it was a structure on one parcel as a whole, then it would not necessarily require these variances.
I'll also add there that all of the driveways on that drive is anticipated to be a private drive that will be managed by an HOA, so it will not be dedicated as a public drive to the city.
Right.
So does that change the standards?
It does not. It doesn't change the standards, no. That's why they've applied for the variance.
So there's no standards for townhouses specifically?
So there are, and their rationale speaks to it a little bit, but townhouses have standards and ordinances tied to them, and it's usually on one property as a whole with someone managing that whole townhouse, and then the people, like the leasees under that, live in the townhouse, right? The conflict is coming in where they want to develop townhouses and then have the people who individually live in them could have ownership of their section of the townhouse. If this was just all managed as kind of one development and individual ownership wasn't a factor, then a lot of that wouldn't be necessarily, but because they're cutting up the lots for individual ownership of your part of the townhouse, then that's where that is coming in with conflict with it. But yeah, there's ordinance standards and things like that. Otherwise, they're compliant with their requirements. It's a permitted use in their district. and none of the other considerations with like townhouse use, they're good on that part.
Okay, so they would have been in compliance if it was under a townhouse standard.
Yeah, except for, it was like those three referenced properties, and only which one of them is involved with like the exterior of the property. So they would, even if it was kind of a whole development, need at least one of the variances, being shoot, I believe it was the depth one. And the rear setback one, which, and that'll be referenced on this one as well. But otherwise, yeah, the internal parking, and then adjacency and frontage wouldn't be an issue.
I'll also add, townhomes are permitted by right in the B2 Service Business District. The main issue at hand is the fact that the lot provisions for the B2 Service Business District are very large. As far as lot size, lot frontage, and things like that go, they're not necessarily directed towards the construction of townhomes, and there is no specific provision in that code that would allow any deviation from those lot provisions that are outlined. So that's the main reason that they've had to request these variance applications.
Yep. And then just quickly, kind of on that last one, VR 26012. The applicant seeking variance regarding setback standards for this use. The project has the 104 townhouses as referenced. The applicant wishes to reduce the side and rear setback requirements for the referenced area. Refer to addendum A and B for further information. In summary, the applicant wishes to get a variance regarding 12 feet of rear setback and 5 feet of side setback at the referenced address. See the attached application to review the findings of fact listed, as staff have had no comments or modifications to these. Planning staff support the applicant's request for this variance. Again, reference the division of internal lots is what is mainly causing the need for this variance. Well, development as a whole is not, with the exception of a couple of the exterior lots. Refer to their findings of fact for kind of the rationale of support with that one as well. And now, since that is the final one, I'll read the condition. If the Board of Zoning Appeals grants the applicant variance relief in accordance with the city's planning and zoning code, the use shall be subject to the following condition, being our one standard condition. With it, as far as the BZA, that's our only condition. As a note, they did go to the Planning Commission and got approval with a condition from the Planning Commission to go to the BZA and receive these variances.
I'll add to that. Last Thursday's meeting, they received conditional approval for both the associated Type 3 Development of Significant Impact Site Plan, as well as preliminary approval, or approval for a preliminary major subdivision to create 104 parcels where they plan to sell these privately, and they will be privately owned. There were conditions attached to both of those, and the relevant action letters were sent out to the applicant today.
Thank you. So with regard to -012 and the setbacks for side and rear, 5 is required, 12 is required, right?
The requirements.
And then they're asking for various variant.
So 5 would be required for the sides, right? Correct. On the rear, it's 40 feet. They're requesting 12. So they're about 28 away at the largest extent.
So basically the issue is like the B2 district like contemplates or allows townhouse use, but it doesn't contemplate multi-unit townhouses.
It's a little bit
essentially
antiquated.
Yeah, it doesn't account for like individual ownership of them. Yeah.
Okay.
Even though townhouses by their nature, right? Do we have a representative for this case?
Yes.
Please approach the podium, state your name and a reference address for this case.
Scott Copen, 170 Old Cheat Road. I'm with Cheat Road Engineering. I'm the designer for the project and the representative for ARJ this evening. I'm gonna put this one up too. I don't know if it might work as a good pointer for me here in a little bit. I tried this last week and it worked perfect. That's the best use of a cell phone I've seen. So just to run through these real quick, the discussion was going there anyways, but really I feel what's bringing all these on, with the exception of the 3 rear setback requests, which I'll get to at the end, It's just the way the code's presented. The code requires, and we'll just go through these real quick, the code requires a 60-foot lot width, front lot width. But B2, in the B2 district, you're allowed to build townhomes by right. So the code says you can build a townhome, but it doesn't have the language to allow a townhome to actually be built based on the typical width of a townhome. The way it's written, you technically have to have a 60-foot wide townhome just to meet that width. So that first variance request 26-08 is to allow for the reduction in the frontage, the width of the lot down to the width of the townhouse. From 60 feet down to a minimum of 20 feet. Does that make sense? And typically,
So you are going down to a minimum of 20 feet for
Yeah.
frontage?
yes, because each unit's 20 feet wide.
All right.
So with regards to that, I don't know if you can see this. Can I move this over there and point to it?
They've got I gave them a couple copies of that as well.
So each townhome unit, if we're looking particularly at an interior unit, is a 20-foot wide townhome. So the lot lines exist within the common walls of the townhome. Therefore, the width of the lot is 20 feet.
Right.
What about the one at the end of the unit?
The one at the ends, we actually are exceeding, well, lot width is still less than 60. Because we have 15 feet between units. So
Okay.
that one's 27 and a half feet on the ends. And that gives us our 15 feet between units, and was gonna get there in a second, but that gives us a 7.5 foot side setback, which is 2.5 feet more than the minimum required
Okay, go ahead.
by the ordinance. And generally speaking, if you look at, and this is not a knock on staff or anybody else, it's just how the ordinance is written. If you look at a standard subdivision ordinance, planning ordinance, say even the Mon County ordinance or West Run, it'll say in this district, the minimum lot width for a single-family detached home is 60 feet. And then below that, it says for townhomes, the minimum lot width is 16 feet.
Right.
Meaning you can build a 16-foot wide townhome if you so choose. I think they know more about the history of the ordinance than I do, but it must not have been contemplated to have individual ownership of townhomes. These aren't rentals, these aren't for students, these are for individual homeowners. And quite honestly, it's the only, I don't know of any other townhome communities inside city limits of Morgantown like this will be.
Can you speak to like variation in terms of lot frontage and structure width among the different districts, B2 versus R versus, is there any?
Really, at least
degree of-
in our ordinance, if you're in, whatever district you're in decides your frontage regardless of your use. Ours, and kind of what he was getting at, is that our districts don't really differentiate between your use frontage and your district frontage. It's more you have a principal structure that has to be, this far from whatever parts of your property line, as well as the property has to be X amount of distance wide. On it.
So with respect to the B2, what's being proposed is responsive to requirements and.
Yeah, part of the rationale for planning's kind of support of this variance is that the structures themselves, the buildings,
Right.
if you took from the farthest left parcel to the farthest right parcel of that building and combined them, then you wouldn't necessarily need this 60-foot variance.
It's the individual units.
It's the
that's
individual
driving.
units that's causing the need for that. With it, but if you looked at like the buildings as like individual buildings by themselves, then the 60 feet isn't
Right.
necessary.
Where,
Or would be required.
in terms of the individual unit issue that we're contending with here, where did the 104 units come from? In terms of my understanding of what's driving the residential density here, if you follow me. Where does the 100?
Why do we have 104?
Yes.
Because I couldn't fit 108. I mean, that's just, that's the bottom line of it, right? So when you're doing residential development, what drives everything is the economics. So when we're looking at yield on the property, there has to be a minimum yield,
Right.
you know, to be able to purchase. And then we have to pay for all the infrastructure, water, sewer, storm, gas, electric.
Right.
The improvements to Everlasting Lane out to Hartman Run, you know, the sidewalks along Everlasting Lane, the area for the bus stop. I mean, that's what drives everything.
Right.
So I don't mean to sound facetious when I say that, but that is the truth.
I was expecting that response, but.
Yeah, and the reason, if you look, we've got quite a large area that we're not building on.
Right.
And the reason for that is it's just not economically feasible, and it's not responsible to build there because of the land grade, the soil conditions, and what have you. So that's how we end up at 104. Right. But it wouldn't matter in this scenario if I only put one block of buildings on that property for individual sale. I'd still be standing here today asking for the same variance relief.
Right.
So lot size is also due to the individual sale of each unit.
That's correct.
Right?
So just so you know, and again, I'm not being negative, but there's nowhere in the Morgantown City Planning Code that allows for the individual development and sale of townhomes. None of the residential districts allow for it. They don't have any separate criteria for townhome lots. There is nowhere in that code that I read, and I looked through it today, that actually allows someone to build townhomes and sell them individually. And that's with the exception of three rear setbacks, which I'll talk about separately because they are a separate issue. All the rest of these are driven by the fact the code just doesn't have the provisions in it for townhome lots, even though by right we can build townhomes.
Well, how's it defined in the code?
How's what defined?
Townhouses. I mean, if there's no code sections on it.
So
Does it say B2 can have them?
They are, per the permitted uses table, townhomes are permitted in the B2 district. The issue is when you go directly to the B2 district and it lays out the lot provisions. Right. It's just basically A, B, C, and D of it has to have this frontage, it has to have these setbacks, it has to have this minimum lot size. The B2 service business district is one of the less restrictive in the city, allows a lot more uses, and those lot provisions tend to be more, associated with a larger detached single-family home or a commercial development, which would also be allowed in the B2 service business district. There is no additional provisioning that says, townhomes are allowed in the B2 service business district by right, so we will allow exceptions to those lot provisions. There's nothing in the code that says that. It just lays out the lot provisions point
Same
blank.
with duplexes, I don't believe.
But you're saying nowhere in the code is there anything about townhouses?
It's defined, like what a townhouse is, but it's the difference between like the definition in our ordinance is townhouses versus this is just individual ownership and sale. If it was all one parcel, and that's kind of per the codes, like standard without needing a variance, is that someone would have a townhouse developed and built, and then they would just maintain ownership, or somebody else would, and then the individual place would be like units, not for individual ownership.
Yeah, if we wanted to turn this into a rental property with 104 rental units, I would be here for one request tonight, and that's one rear setback in the upper left corner. We wouldn't even be here discussing this. It's like when the code was written, which obviously predates anybody in this room, the individual sale of townhouse lots wasn't contemplated.
Right.
It says you can build them. They just never contemplated somebody might want to sell them, which is kind of weird.
And in terms
of... This is a private road?
Yeah, so just very quickly, the road from Everlasting Lane, you can see the lot line on the right side there. From there in is all private, will be privately owned. It's do you remember what that 28A community, I believe is what they call it? That's all dictated by West Virginia state law. So it'll have a homeowners association, they'll pay dues, they'll be solely responsible for maintenance of the roads, and the storm, water and sewer, obviously will be owned by MUB, operated by MUB, electric by the power company. But the HOA documents, all have to be submitted and approved as a condition of the DSI and subdivision approval we received last week.
Right.
That all has to be reviewed and approved by the city to show that, yes, there will be an HOA created, and no, they can't come back in the future and decide they don't want to take care of the roads anymore. Like, that's all part of that. They don't want to, there have been instances in the past, happened quite a while ago in the South Hills region, where somebody built roads.
Oh, yes.
And,
Well, when you said that, that made me think
Yeah.
of Eastgate too.
same type of thing, yeah.
Yeah.
Yeah, so, and the goal is, you know, from the city and our standpoint, obviously, we don't want to have that happen, so it's being taken care of legally. The attorneys will be involved in that to make sure that that group of people can't come forward someday and say, hey, we're in the city and we pay taxes and you have to take care of our roads. We're putting that in the deeds, it'll be restricted, so they can't do that.
Right.
That's a condition of the DSI and the subdivision approval.
And I'll also add that, you know, as part of that type 3 development of significant impact process, when we held the technical review meeting, engineering and fire were both given the opportunity to provide feedback on some of the standards of that. So the standards in this site plan are reflective of the comments that the engineering department as well as the fire marshal provided as well.
Right.
So why the change in lot depth for the,
Lot depth.
like
Can you
how
bring that
long
back
they
up?
are?
Yeah, because the requirement is 6,000. Is that the one,
No,
the
it's the one
second
that
one?
goes from front to back, right? It's depth.
Yeah, front to back. So generally speaking, the way the 100 feet depth, as I interpret it, was to achieve, if you look at the way the code is, it's 60-foot wide minimum, 100-foot deep minimum, a 6,000 square foot lot minimum.
Okay.
Right.
Okay.
So they kind of all go together.
Yep.
And when you look at the land and the way that I was able to lay the project out, with the exception of those 3 lots where I have an issue with the rear setback, which again, we'll talk about separately.
Yeah.
I'm not encroaching into the backyards of these things. And if you look at and I shouldn't say encroaching in the backyard, the buildings are not encroaching into the rear setbacks. So a shorter lot doesn't affect anything from a setback standpoint or distance from a exterior property line or anything like that. And when you get away from the 60-foot minimum width in the 6,000 square foot minimum area, the 100-foot just doesn't, it doesn't play into a need for a townhome community, to be honest with you.
Okay. So the driveway variance was for the individual driveway of the home, right?
Yeah, so that's for the driveway in between, and again, I'll use my.
Yeah, feel free.
So that's for this driveway here, 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 and here. And the way the townhome units are set up, if you think of a standard townhome, you stand facing and looking at it, there's a garage on one side, in this case, the garage will be on the left. It's a 10-foot wide opening, normally it exists about 2 foot off the left-hand side, the start of that opening. And they'll pour a driveway right up to the left side of that unit, or within inches of it, within about 0.25 feet.
Right.
Which is why I'm asking for that. So that means that technically, the distance from that driveway to the adjacent unit is 3 inches.
Oh, yeah, right.
It's just how townhomes work.
Okay.
Yeah.
And I'll add, the request for that variance comes from a specific provision in the code that says that driveway entrances and exits cannot be closer than 15 feet from an adjoining residential property line, but with the construction of the townhomes and then being connected to one another, that was just part of the variance package.
Will there be immediately adjacent to the drive that's going to access the stall? Are you anticipating another spot immediately?
No,
for 2 vehicles?
No, these are single width driveways.
Okay.
And they'll actually be, if you see, I had some color on there, but it gets really messy. But these little white areas in here.
Right.
And they are, I mean, they're not big lawns, but those are green space landscaped areas.
Right.
So you've got one car to park here.
Right.
And then obviously one in the garage, and we've got we've got visitor parking throughout the development.
Okay.
But thankfully, the builders have changed a little bit in the recent years, and they've got away from the sea of concrete, you know, that you see in a lot of places, and they do want to get a little front yard in there, or
Right.
landscaping or something.
And each unit has a 2-vehicle requirement, right?
Correct, yes. So they'll all be 3-bedroom units. The determination per the code is 0.75 spaces per occupant, which would equal 2.25 spaces per unit, but there is a specific provision in the code that also says when you're calculating that unit of measurement, that if you end up with a fraction of 0.5 or less, to round down, 0.5 or more, round up to the next space. So it's 2 spaces per unit. We also it'll be a 1-car driveway, but there will be also a 1-car garage. We did consult, as part of the DSI application, consulted the APA Planner's Dictionary to determine that garage parking did suffice to meet and count toward the off-street parking requirement.
Do you feel comfortable with that, like practically speaking, you know what I mean?
Yeah.
Practically speaking. And not everyone is gonna have 2 vehicles necessarily, but still.
Right, but still, yeah, townhomes are typically small, narrow to get in, narrow to get out. So the last one, regarding rear setbacks, could you speak to that one then?
Yeah, so there's actually 2 things in there, and I guess they got the tables, right?
Yeah. Yes.
Yeah, so there's one table that should reference side setbacks, and one table should reference rear setbacks.
And they do.
Yeah, so just quickly, the side setbacks again are because we have townhome units.
Right,
Side
you already
setbacks
mentioned
are
that.
0 internally.
Okay.
Our end units, like I said, we've got 7.5 foot. We're only required, that the code requires 5, so we're a little bit bigger there. So rear setbacks, there are 3 units.
Could you point them out, please?
Yeah, I will. 2 of them are internal, here and here. And 1 is on the exterior, which is over here.
Okay, and how does that one differ from the others, please?
And what?
How do those 3 differ from the others? You said there was 3 that, those ones.
Those are the only 3 that don't currently,
Meet
that
the
don't meet
rear.
the 40-foot rear setback
Okay.
requirement.
Okay.
Yeah. All the rest of them do. This is internal, you know, obviously, we're not affecting an adjacent property or anything
Right.
like that. The other thing to keep in mind with these units, the way these are built, you've got the building and then a 15-foot yard, and then it's sloped going up or down.
Okay.
So these units are actually, from the second floor, you can see these units, you can see these.
Okay.
From the back floor basement, there's actually a hump in here. You'll be able to see the roof line of this building, and you'll be able to see from here the roof line of this building, but you won't be looking straight in or backwards.
That's good to hear.
This one, which is, I think, let me make sure, yeah, that's the 11-foot setback. This abuts the city property
Okay.
on a very steep sloped area.
Right.
That's just not.
Not developable.
It's not developable. So we're not backing up against a neighboring house or an existing land use or anything that's even potentially in the future going to be built.
Not even sight lines, really.
Yeah, no.
I mean, all these variances are based, like, these code requirements are basically to prevent underdevelopment, right? And that's obviously not the problem here.
Yeah.
Like, there's a lot of development going on, aside from maybe the setback,
Yeah,
the rear setback.
except for these 3. All the rest of these are related to the fact that the planning code just doesn't have the provisions in it yet.
Yeah, I can't speak to, what's being proposed, there are a lot of townhouse.
Variances.
No, there are other developments that are very similar to this. Not necessarily within city limits, but around the county.
Yes, Dan Ryan.
And if those other comparable developments, if they were problematic, we would know that they're problematic.
Yep.
So in other words, what I mean is what's being proposed is not.
Well, and to that regard, this is a more, I know it looks like we're cramming them in there, and I get that. But this is this is a less dense townhome community than what you would typically see elsewhere in the county. And I know that because I've designed many of them. And we wouldn't have all that empty space in there. We would figure out a way to put the units.
If
The ones across from
Yeah.
Suncrest, are those all rentals? Those
Where,
are-
where at?
Across from like Suncrest Town Center?
No, those are ownership. I mean, some of them are rented by the owner, but but that's outside the city of Morgantown.
Okay, ask me.
I don't know of any other townhome communities inside city limits like this.
Well,
That
that's
are
why I
single-
said-
that are single
That's why I
ownership.
said not necessarily in city limits, but within, certainly
Yeah.
within the county.
Stewartstown
There's
Road
one-
outside the city?
Yes.
Oh, it is?
Yeah, I live on it.
This is making me think there's one over Westover Way,
But that's not inside.
overlooking the river.
that
That
inside
reminds
city?
me of this.
Yep. It is similar, that there are some distinct differences here because of the city. We've got more, and because of the way they wanted to build this one, you won't find that many off-street parking or visitor parking in any other
Yeah, I thought
community.
that was
And,
very
and to be
nice.
honest, if I could put 20 more in, I would, but city code says you can't. I'd be here asking for another
I'm a little
variance.
concerned about the parking. Like if each one of these townhome residents does in fact have 2 vehicles, just you know what I'm saying, using the driveway and then.
I would say to that.
Can you speak to
I know
that?
what you're saying. I'm not saying that one way or
Just
another.
because the frontage is, I mean, it's
But
right there.
that part of the project's already been approved last week by the
Right.
planning commission.
Okay.
You know, there's no requirement for me to come and speak to you about I don't need a variance request, let me put it that way, for the parking.
For the parking.
I would prefer we had more parking. The developer would prefer we had more parking, the builder would prefer we have more parking. That is the maximum amount of parking I can provide by city ordinance,
Right,
without getting another variance.
yeah.
I felt the number we had was probably
Yeah, for these, for.
getting up there.
For
But we
Generous.
can, yeah, I can't, and even if you go to because we had this discussion last week about the 2.25,
Yeah,
even if you carry the 0.25 through, we would be required to have 234, and we're providing more than the minimum in that, on that standard as well. So we're doing what, we're providing the parking we're required to provide.
Yeah, the board could vote on extending their maximum requirement, but you couldn't make them provide more as a minimum. They're meeting their minimum for parking requirements. And like you said, you're only allowed, I believe, 115% or so spaces. If you go beyond that, you need to seek a variance for that. And they're at that 115% of parking spots.
yeah.
If they added one more space, it would have required a variance.
I had more spaces and we reduced it to avoid.
Yeah, there's a provision in the code that says they may not exceed 115% of the minimum requirement.
Yeah.
So he's providing 239, which is equal to, but does not exceed that 115.
That
Yeah.
seems like an odd.
I think in terms of.
Do you have another one on that empty hump over there?
Yeah, I had more on the left side and more on the right.
On the curve.
Yeah, yeah. Because we do want a more livable townhome community than what you see a lot of times.
And that's kind of why there's also that cap on it, so people just don't, seas of concrete kind of thing.
Yeah.
Or make a parking lot and call it a house, but really they just are making a parking lot that has a home attached to it, right? For that, so that's kind of a little bit of the rationale of why there's a cap on it. It doesn't happen often that people meet that cap. It's usually meeting the minimum.
It seems.
So there's gonna be a bus stop there too.
Yeah, so the bus stop goes out at the,
Where's the bus stop?
the bus stop will be out here at Hartman Run Road.
Oh.
Oh.
Mountain Lion had asked us to put that bus stop in. Ideally, I can talk to the Board of Education and maybe get them to, and come back out, but it's probably not gonna happen. The bus doesn't go, to my knowledge, my understanding, the bus doesn't go up Everlasting Lane.
Right,
So the bus stop at the direction of,
that makes sense.
city staff and
Yeah.
Mountain Lion was out here. parking.
Right, yeah.
So we're actually parking, just so you know, Everlasting Lane's like 16, 17, 18 feet maybe. We're widening Everlasting Lane to 22 feet to our entrance and putting a sidewalk, clear around the perimeter of our development and down to that bus stop.
Right.
It's gonna be a
And
good
we're
exercise.
gonna do all of
Yeah.
our widening on our side of the road.
Okay.
Because there is a existing, residence here. They're outside the city, but that doesn't really matter. They've got, they live here, and they've got some off-street, parking that backs directly onto Everlasting Lane.
Right.
So we're not doing anything in our direction. We're taking all of our work to the opposite side so that we don't negatively, adversely affect it. And we actually have a area down here that we have to, we're granting, right away to DOH, to be able to do that. So that they have the adequate right of way they need to maintain their routes.
Okay.
Okay. In terms of the variant, the one that gets me is the minimum, the lot size. Taking it from the 6,000 down to the 1,750.
Why?
That degree of difference, just,
But this is like, these code sections are basically what they're like anticipating is like one building per lot.
One house, yeah.
And so
Right.
they have
No,
those
I get it.
minimums
It's-
because they
again,
don't
it's
want
the
you putting some
individual.
tiny place on a lot.
Right,
But that's
right,
not,
right.
obviously isn't what's happening here. Like, there's a lot of development. It's not like they're putting a little shed on this entire parcel.
And to maintain that 6,000 square feet, we'd have to have a lot that's 300 feet deep. A football field,
right.
you know, which is, that's a lot of grass.
It'd be interesting.
For a
Yeah.
townhouse.
Yeah.
You could put a driving range behind it.
Yeah, exactly, yeah.
Apart from that, I really don't have.
Open the public hearing.
Are you all set? Anything
Yes, no,
further to
please.
add, or? Okay, we're gonna go ahead and, before we open the public hearing, because there are 5 individual variances under consideration, but for purposes of conducting the public hearing, we're going to combine the cases with respect to public comment bearing on the public hearing. So we're going to go ahead and open the public hearing for these 5 related cases, -008, -009, -010, -011, and -012, all at 264 Hartman Run Road. Anyone wishing to speak in support of or in opposition to this case, now is your opportunity to do so. Any correspondence received? No. And in terms of planning conditions, just the standard.
Yeah, just the standard condition for the BZA. There was other conditions on the planning commission and other things that they've gone through, but instead of copying those over, the Board of Zoning Appeals only has one.
Right. Anyone wishing to comment? Seeing no one, we're going to close the combined public hearing for the 5 variances. Any other discussion, any further questions? Okay.
I don't have anything else.
So,
So when, for voting on these, you will have to kind of approve or deny them all separately. So,
Right.
vote to 008, findings of fact and variance for that, and then individually.
and we do want to note, of course, that there are separate findings of fact for each variance.
That is correct.
So, do we want to, is everyone comfortable with the individual bodies of finding of fact for each?
Yeah, I am.
Are we voting on them all at the same time?
No, we have to do
Oh,
a
yeah,
motion
I
on
thought,
each.
okay.
So,
A
If there's no further discussion, so I move that we approve the findings of fact relating to VAR 26-008. And this specifically, this is a variance for, or bearing on the lot frontage for this application.
A second.
So we have a motion to accept the findings of fact bearing on VAR 26-008 relating to the lot frontage. And we have a second. How do we vote?
Aye.
Aye.
Aye. I guess we'll, all right, so now we need a motion to grant the variance. We'll just do the findings of fact and then the variance.
Right.
So I move to grant the variance, the requested variance for VAR 26-008. Again, this is bearing on the lot frontage issue for this application.
Second.
We have a second by Mr. Misfelt. How do we vote?
Aye.
Aye.
Aye. So that variance is granted. I move to accept the findings of fact bearing on VAR 26-009. This relates to the variation in lot size for the proposed application. Do we have a second?
Second.
We have a second to accept the findings of fact for VAR 26-009. How do we vote?
Aye.
Aye.
Aye. I move that we grant the variance for VAR 26-006
Second.
for the lot size issue.
Wait a minute. I mean, 009.
I'm sorry, let me restate that. So I move that we grant a variance for VAR 26-009 relating to lot size.
Second.
And we have a second by Mr. Misfeld. How do we vote on that particular motion?
Aye.
Aye. Right. I move to accept the findings of fact for VAR 26-010. This is for lot depth, and we have a second for that motion to accept the findings of fact. How do we vote?
Aye.
Aye. I move to grant the variance for VAR 26-010 relating to lot depth for the application. Do we have a second?
Second.
Okay, we have a motion to grant the variance for 26-010, seconded by Mr. Misfelt. How do we vote?
Aye.
Aye.
Aye. I move, and if anyone wants to jump in and make a motion. Go right
Well,
ahead.
you started, go ahead.
You had a
Sorry.
flow go.
So I move to accept the findings of fact bearing on or relating to VAR 26-011.
Second.
And this is relating to the driveway layout and design. And we have a second by Mr. Misfelt again. How do we vote?
Aye.
Aye. I move to grant the variance request for VAR 26-011 relating to driveway layout and design with distances between adjacent properties.
I'll second.
We have a second by Ms. Cook. How do we vote?
Aye.
Aye.
Okay. So I move that we grant the variance for 26-011 for driveway layout and design. We have a second for that.
Second.
Motion to grant, okay. We have a motion to grant the variance for VAR 26-011 relating to driveway layout and design. Second by Mr. Misfelt. How do we vote?
Aye.
Aye.
Aye, so we've granted that variance. Last variance for this application is VAR 26-012. This is to accept the findings of fact relating to -012 And this relates to the rear setbacks for the application.
I second.
We have a second by Ms. Cook. How do we vote to, do we vote to accept the findings of fact for
Aye,
this?
yeah.
Yes, we do.
Aye.
Do you? Okay, so that, we've accepted those findings of fact. VAR 26-012, relating to rear setbacks for 264 Hartman Run Road. Do we have a second for that motion?
Second.
All right, we have a second by Ms. Cook. How do we vote on that last variance request?
Aye.
So we've granted your 5 related variance requests for your application. You will receive written notification from planning. The determination we just rendered is subject to appeal, Mon County Court of Appeals. It's a 30-day appeals window. Any further work that you undertake, you do at your sole financial risk. Thank you very much.
Thank you.
Thanks for coming down this evening.
You guys have a good evening.
You too. All right, I think that concludes our all business, new and old and new, sorry. Do we have any announcements from staff?
We do have some on the agenda for the March meeting, so, planning for the regularly scheduled March meeting. Otherwise, I believe that is it. Is there anything else?
I don't have anything to add.
No, that is it.
Well, I mean, the signage ordinances are,
Yeah,
there's something in the works with regard to signage.
There is an update coming on a overhaul of the sign ordinance. I actually, if you could hang around for a little bit just after we're done here to talk about that a little bit, but otherwise on the public end or anything, nothing's ready yet. But there will be kind of an overhaul coming to hopefully address some of the repeated
neon
sign illumination standards, among other things. So, but we'll get to that when we get to it. Otherwise, nothing else.
My question is how does this particular case affect moving forward? Because we've actually set precedents now.
With which case?
With lot width, lot depth, driveway layout and design. Does that go into the, for consideration to go into B2 zoning district?
I don't believe it would have any real precedent on the general B2. I think this is more of, and you guys have spoke to it when you were discussing with the applicant, the kind of rationale, the specifics of this development, its size, there's a lot of points that you guys brought up that would differentiate it between, someone wanting to just do a smaller, maybe try to get around some of the ordinance for its purpose of having proper lot size. For the reasons of topography was brought up, as well as individual sale, townhouses specifically being referenced, the size of the development, the other work that they're making more compliant by nature of this. So I believe the determination was made with different points that makes it unique to this variance request,
right?
And not necessarily applicable to everything in a B2 or every townhouse in a B2. Example.
So all those people, they're going to own those parcels in a B2, so they could turn their townhouse into a business.
So they wouldn't be able.
Well, I guess they'd have the HOA to deal with them.
Yeah, they have the HOA to deal with, as well as a part of their requirements of this is all getting approved as a townhouse use. If that use changes, then they're applicable to the standards of whatever their new use is.
We approve, in other words, we approve them as a townhouse.
Yes, this was all approved as their townhouse development use, and the uses that are assigned to these will be townhouses. If those were to change to either a compliant or potentially non-compliant use, they would have to either get variance or they would have to be compliant with the current standards. So you couldn't necessarily take one of these and turn it into a restaurant, right? They would most likely be non-compliant.
Because even though the structures are in a B2, they're still approved as townhouses.
Yep, correct.
Yep.
I move we adjourn.
All right, we have a motion to adjourn.
Second.
We have a second. All those in favor?
Aye.
Aye.
We are adjourned.